My name is Corinne Tierney, and I wanted to thank everyone for joining us today on the webinar. I presented on the New York City Local Law 144, a law which is designed to require employers and employment agencies using automated employment decision tools in the hiring or promoting of employees. That is New York City resident employees or candidates or applicants. To disclose a summary of results from an independent bias audit with respect to their selection rate, their scoring of applicants, and their candidates. While the law is currently in effect, it was placed in effect January 1st of this year. It's fortunately not enforceable until July 5th, 2023. So employers and employment agencies that this law applies to, they have some time to become compliant. But now is definitely the time to start considering your practices and determining whether this law applies to the tools that your company is specifically using. And I think that the enforcement date was actually pushed back following several proposed revisions to the original draft of the law, as well as a couple very well-attended public hearings. So essentially, the law is designed to create more transparency in an employer's hiring practice when that employer or employment agency uses an automated employment decision tool, which does include the use of artificial intelligence or AI. The law also requires a notice to be distributed to New York City resident applicants 10 business days, not 10 calendar days, 10 business days before the AEDT is used to evaluate or score them. While the recently adopted rules cover many definitions, such as what kind of bias auditor qualifies as an independent bias auditor and what types of data may be used for the public disclosure provision of the law also does provide formulas and structures for data sets to be provided by the employer or the employment agency using an active hyperlink to their website. Really, one big important thing to take away from the new rules is that you'll really want to sit down with your employment attorney and determine whether this new narrow definition of AEDT actually applies to an employer or employment agency's use of any kind of tools, AI or otherwise, during the hiring or promoting process. Because again, this is really a transparency rule. It's a disclosure and notice rule. That's really all it is. Definitely take some time to listen to or watch the webinar if you have more questions. There are some definitions. There are the penalties associated with failing to properly comply with this law. That's also kind of fleshed out a bit more in today's webinar. But in addition to my broad overview of New York City Local Law 144, and that's what it is, it's a very broad overview, Liz Heifetz discussed Bond's pro bono work in immigration law, as well as a brief legal update regarding the rescission of Title 42 and its challenges. She also discussed opportunities available to both attorneys and the public in the area of immigration law, which is a big topic. And finally, Gabe Overfield discussed budgets in New York City and New York State, as well as a general overview of the wind down of the current public health emergency in place. Paige Carey actually fleshed this out a bit more and discussed the ending of the public health emergency and the national health emergency related to COVID-19. And she really discussed how these impact institutions of higher education. So for additional legal updates, please continue to tune in each week and don't hesitate to contact any of our presenters with any of the questions that you may have. Thank you.